Similarly, the constitutionally entrenched judicial authority is vested in the courts, and so too is the independence of the courts, which is subject only to the Constitution and the law, which must be applied impartially without fear, favour or prejudice. As in the case of the prosecutor and prosecutors in general, no person may interfere with the functioning of our courts. Prosecutors' independence must be understood in such a way that political, personal and private consideration must be set aside so far as the exercise of discretionary powers is inherent in the office of the prosecutor. No matter how much pressure is put on him due to the heinous nature of an offence, the surrounding publicity or the parties involved, the prosecutor must retain an inward sense of impartiality and display outward objectivity. Insofar as the investigation into the establishment of the SARS high-risk unit is concerned, I have inter alia been advised of the following: the need to create a unit which would penetrate the illicit market to investigate the losses of revenue that SARS was suffering in that area had purportedly been identified as far back as 1999. Such a unit had to be located within the intelligence services, although it would focus on SARS work. In this regard, numerous meetings and various interactions between SARS and the various intelligence agencies, namely the National Intelligence Agency, as it was known at the time, the South African Secret Service, as it was known at the time, the Defence Intelligence and Police Intelligence, took place between the periods 1999 and 2007. On 2 February 2007, Mr. Ivan Pillay, who at that stage held the position of General Manager of the Enforcement and Risk Unit at SARS, directed a memorandum to the Minister of Finance, Mr. Trevor Manuel, who was the Minister at the time. This memorandum was titled "To Fund an Intelligence Capability within the National Intelligence Agency in Support of SARS." In this memorandum, Mr. Pillay sought Mr. Manuel's approval to fund a special capability within the National Intelligence Agency to supply SARS and law enforcement with the necessary information to address the illicit economy. This specialized capability was ostensibly required to enable SARS to understand the illicit trade industry, which purportedly was responsible for SARS losing income in respect of the collection of vast amount of revenue required to fund government's priorities. The areas which the purported unit or the proposed unit would focus on inter alia included the following: organized crime groups. This memorandum inter alia emphasized that collecting tactical intelligence invariably means penetrating and intercepting organized crime syndicates. This memorandum significantly acknowledged that this is an activity for which SARS did not have the capability, including the legislative mandate, to manage clandestine activity. The memorandum further alludes to discussions which were taking place with the National Intelligence Agency to supplement SARS's intelligence capability. The memorandum further critically informed Mr. Manuel that the National Intelligence Agency was willing to create a ring-fence capability on the proviso that funds are made available to cover personnel costs, as all other costs will be covered by the National Intelligence Agency. To this end, Mr. Manuel was further advised in the memorandum that the National Intelligence Agency was willing to formalize the above-mentioned arrangements into a memorandum of understanding. No memorandum of understanding in this regard was ever entered into between SARS and the National Intelligence Agency, nor between Mr. Trevor Manuel and Mr. Ronnie Castrols, who was the Minister of Intelligence at the time, nor between the Director General of the National Intelligence Agency and the Commissioner of SARS. Neither was a ring-fence capability created within the National Intelligence Agency. The aforementioned memorandum further requested Mr. Manuel to increase the budget of the National Intelligence Agency to fund the creating of this specialist capability. It further sets out the estimated personnel costs for the period 2007 to 8, 2008 to 9, and 2009 to 10. For purposes of this briefing, I will not allude you to the amounts of money that was estimated at the time. There is no evidence remotely that the National Intelligence Agency's budget was increased to fund this specialist capability. Minister Gordhan, who was the SARS Commissioner and the SARS Accounting Officer at the time, in approval of the request by Mr. Pillay, signed this memorandum on the 8th of February 2007. Whilst the Deputy Minister of Finance at the time, Mr. Jabu Mulaketi, approved the request as per the content of the memorandum on 22 February 2007. In approving this memorandum, Deputy Minister Jabu Mulaketi remarked as follows in a handwritten note, open quote, "Supported. However, this is a strange way of executing what I require to be an economic mandate of NIA." And I pause to state that's in reference to the National Intelligence Agency. I continue. "It seems as though it's an add-on rather than part of NIA's mandate." Close quote. Mr. Manuel reconciled himself with this handwritten comment of his erstwhile Deputy Minister and approved the memorandum thereafter. Investigations have further revealed that members of the unit were recruited to SARS prior to the authorization of Mr. Manuel being obtained and prior to any memorandum of understanding being entered into. There was, of course, as you know now, no memorandum of understanding ever entered into. Investigations have further revealed that the high-risk investigation unit had been in existence in SARS and had been operating long before Mr. Manuel's authorization had been obtained. This unit, inter alia, conducted its affairs in a very strange and covert manner, in that members of this unit were recruited outside of normal SARS recruitment processes. Members of the unit were sourced from structures such as the South African Police Services, the National Intelligence Agency, the Directorate of Special Operations, the former Scorpions, the South African National Defence Force, the South African Revenue Services, and of course the private sector. Unlike other South African Revenue Services employees, members of this unit did not operate from SARS offices. Instead, they operated from their houses, booths of cars, or from guest houses, from coffee shops, and from the residences of other members. Members of this unit did not report for duty during normal office hours like other employees and conducted clandestine and or covert operations. Members of this unit were also assigned SARS identification cards with alias identities. A typical example of this unit's covert operations, to mention but one, is Project Sunday Evenings, which involved the procurement and installation of covert equipment utilized for spying activities at the offices of the National Prosecuting Authority in 2007. no authorization for undercover operations, nor the authorizations of the designated judge were obtained by members of this unit for interceptions. Minister Gordhan was offered an opportunity to provide his version on the legality of the establishment of the high-risk investigation unit within SARS, which version he submitted to the Hawks through his lawyers, in which he inter alia stated that the establishment of the high-risk unit within SARS was legally done and it operated within a legal framework. In addition thereto, Mr. Gordhan had also stated that had any members of this unit conducted their activities outside of the law, they did so without his knowledge. Chapter 3 of our Constitution requires cooperative governance. In this regard, Section 40, subsection 2 of the Constitution makes it peremptory for all spheres of government to observe and adhere to the principles enunciated in Chapter 3, and further obligate spheres of government to conduct their activities within the parameters of the said chapter. Section 41, subsection 1 of the Constitution provides, open quote, all spheres of government and all organs of state within each sphere must, A, preserve the peace, national unity, and indivisibility of the Republic, B, secure the well-being of the people of the Republic, C, provide effective, transparent, accountable, and coherent government for the Republic as a whole. D, be loyal to the Constitution, the Republic, and its people. E, respect the constitutional status, institutions, powers, and functions of government in all other spheres. My emphasis. F, not assume any power or function except those conferred on them in terms of the Constitution. Again, my emphasis. G, exercise their powers and perform their functions in a manner that does not encroach on the geographical, functional, or institutional integrity of government in another sphere. Again, my emphasis. And at H, cooperate with one another in mutual trust and good faith by 1, fostering friendly relations, 2, assisting and supporting one another, 3, informing one another of and consulting one another on matters of common interest, 4, coordinating their actions and legislation with one another, 5, adhering to agreed procedures, and 6, avoiding legal proceedings against one another. The long title of the South African Revenue Services Act, inter alia, reads that the purpose of this act is to provide for the efficient and effective administration of the revenue collection system of the Republic. SARS's objectives are enunciated in Section 3 of the SARS Act. As inter alia, the efficient and effective collection of revenue and control over the import, export, manufacture, movement, storage, or use of certain goods. SARS's functions in order to obtain its objectives are listed in Section 4 of the SARS Act, which reads, 1. To achieve its objectives, SARS must A. secure the efficient and effective and widest possible enforcement of 1. the national legislation listed in Schedule 1, and I pause to state, I've been advised that no intelligence and security legislation is listed in Schedule 1. 2. Any other legislation concerning the collection of revenue or the control over the import, export, manufacture, movement, storage, or use of certain goods that may be assigned to SARS in terms of either legislation or, I emphasize, an agreement between SARS and the organ of state or institution concerned. B. Advise the Minister on 1. all matters concerning revenue, and 2. the exercise of any power or the performance of any function assigned to the minister or any other functionary in the national executive in terms of legislation referred to in paragraph A. And 2, SARS must perform its functions in the most cost-efficient and effective manner and in accordance with the values and principles mentioned in Section 195 of the Constitution. In this regard, Section 195 of the Constitution provides for the basic values and principles governing public administration. In terms of Section 5, subsection 1 of the SARS Act, SARS may do all that is necessary or expedient in the proper performance of its functions. This, inter alia, includes obtaining the services of any person, including any state department, functionary or institution, to perform any specific act or function, performing any specific act or function within SARS's competence on behalf of any other person, including any state department, functionary or institution, engaging in any activity, whether alone or together with other organizations in the Republic or elsewhere, to promote proper, efficient and effective tax administration, including customs and excise duty administration, and further, to do anything that is incidental to the exercise of any of its powers. Chapter 11 of the Constitution makes provision for security services. In this regard, Section 199, subsection 1 of the Constitution, specifically provides for the security services of the Republic to consist of a single defense force, a single police service, and any intelligence services established in terms of our Constitution. Subsection 4 makes it peremptory for security services to be structured and regulated by national legislation, and subsection 5 obligates security services to act and to teach, require their members to act in accordance with the Constitution and the law. Section 209 of the Constitution enjoins, and I wish to emphasize this, the President of the Republic as head of the national executive, as the only one who may establish any intelligence service other than any intelligence division of the Defense Force or the police service. The President may, however, only exercise such power in terms of national legislation. Section 210 of the Constitution provides for the regulation of the powers and functioning of intelligence services along with the monitoring thereof. In this regard, Section 210 of our Constitution reads as follows, open quote, national legislation must regulate the objects, powers and functions of the intelligence services, including any intelligence division of the Defense Force and Police Service, and must provide for A, the coordination of all intelligence services, and B, civilian monitoring of the activities of those services by an inspector appointed by the President as head of the national executive. Close quote. This, of course, is in reference to the Inspector General of Intelligence. There is no evidence remotely that former President Mbeki invoked Section 209 of the Constitution to establish intelligence capability within the South African Revenue Services. Had such a decision been made by former President Mbeki, such decision would have amounted to an executive decision. Section 101, subsection 1 of the Constitution makes it obligatory for a decision by the President to be in writing where such decision is taken in terms of legislation and or where such decision has legal consequences. Subsection 2 requires the written decision by the President to be countersigned by another cabinet member where the decision concerns a function specifically assigned to that cabinet minister. In this regard, there is no evidence remotely that President Mbeki or President Zuma, when the latter assumed the position of President of the Republic, had taken such a decision, nor was such a decision countersigned by Mr. Ronnie Kasrils, Minister Siyabonga Cwele, or Minister David Mahlobo during their tenure as Ministers of Intelligence and Ministers of State Security, respectively. Nor by Mr. Trevor Manuel, Minister Pravin Gordhan, nor Mr. Nhlanhla Nene during their respective tenures as Ministers of Finance. Chapter 11 of our Constitution further makes no provision remotely for SARS to fall within the category of security services and or an intelligence structure. The National Strategic Intelligence Act 39 of 1994 inter alia defines the functions of members of the national intelligence structures. In this regard, Section 1 of the National Strategic Intelligence Act does not include SARS as a national intelligence structure. This section further provides that relevant members of the national intelligence structures mean A. the Intelligence Division of the National Defence Force, B. the Intelligence Division of the South African Police Service, C. the National Intelligence Service, and D. the South African Secret Service. Section 2 of the National Strategic Intelligence Act sets out the functions relating to intelligence insofar as the relevant members of the national intelligence structures are concerned. It is clear from the above that SARS is not included as a relevant member of the intelligence structure. Section 3 of the same Act provides for the functions of other departments of state with reference to national security intelligence. To this end, Section 3, subsection 1 reads as follows, open quote, if any law expressly or by implication requires any department of state other than the agency or the service to perform any function with regard to the security of the Republic or the combating of any threat to the security of the Republic, such law shall be deemed to empower such department to gather departmental intelligence and to evaluate, correlate, and interpret such intelligence for the purpose of discharging such function, provided that such department of state shall not gather departmental intelligence within the Republic in a covert manner. My emphasis, close quote, of course. Section 1 of the National Strategic Intelligence Act defines departmental intelligence as meaning intelligence about any threat or potential threat to the national security and stability of the Republic, which falls within the functions of a Department of State and includes intelligence needed by such department in order to neutralize such a threat. It is hence indicative and instructive to note that Section 3, subsection 1 of the National Strategic Intelligence Act finds no authority and applicability in justifying the clandestine and the covert functions and the conduct in both the creation of the High Risk Investigation Unit in SARS, along with the operations of the said unit and its members, the persons to whom the members reported to, and the authorities who authorized its establishment, continued existence, and subsequent operations. The aforementioned section clearly finds no authority and applicability in the functions and or conduct of SARS. From the above, no other conclusion can be deduced other than that the creation of the SARS High Risk Investigation Unit is both in conflict with and in violation of the legal mandate of SARS in terms of the SARS Act, the National Strategic Intelligence Act, and Chapter 11 of our Constitution. Similarly, the clandestine and the covert operations of the said unit and its members, the persons to whom the members reported, the authorities who authorized the unit's establishment, the authorities who maintained its continued existence and subsequent operations were too in conflict with and in violation of the legal mandate of SARS in terms of the SARS Act, the National Strategic Intelligence Act, and Chapter 11 of our Constitution. That being said, the investigation into the creation and subsequent operation of the SARS High Risk Investigation Unit is at an advanced stage, but at this stage remains incomplete and is ongoing. You would do well to be reminded that numerous related investigations were conducted which resulted in inter alia findings and recommendations being made. Some of these recommendations, inter alia, included criminal investigations into the creation and clandestine operations of the High Risk Investigation Unit in SARS and its members. For purposes of this briefing, I am deliberately not going to go into the merits and or demerits of the alleged clandestine activities of this unit. I, however, do call on the public to allow the authorities to conclude their investigations. Of course, we will make an announcement on the outcome of these investigations once same has been concluded. I have further been advised by the Acting Special Director and Head of the Priority Crimes Litigation Unit in my office, Dr. Tori Pretorius SC, of a decision made in consultation with the Director of Public Prosecutions for North Gauteng, Advocate Sibongile Mzanyati, on the recommendations of prosecutors in the Priority Crimes Litigation Unit in respect of an early retirement penalty that SARS had paid on behalf of Mr. Ivan Pillay. Parliament's Standing Committee on Public Accounts, commonly referred to as SCOPA, has as recent as September this year, inter alia, called on the dire need to root out corrupt activities, financial mismanagement and maladministration in state departments and SOEs. SCOPA has further called on tough action to be taken in respect of alleged contraventions of the Public Financial Management Act. In this regard, in respect of an early retirement penalty that SARS had paid on behalf of Mr. Ivan Pillay, I have inter alia been advised of the following. During 2009, Mr. Pillay's application to purchase pensionable service for the period 28 February 1980 to 27 April 1994 to enhance his retirement benefits was approved by the Government Employment Pension Fund. During August 2010, Mr. Pillay, who was a SARS Deputy Commissioner at the time, and I think he was 56 years old. He was 56 years old at the time, submitted an internal memorandum to the Commissioner of SARS, who was Mr. Opa Magashula at the time. This memorandum, inter alia, informed Mr. Magashula of Mr. Pillay's decision to retire early. It further explained that the decision to retire early is largely informed by his deteriorating medical condition and family responsibilities which had suffered as a result of his dedication to his job at SARS. Mr. Pillay further requested to be reappointed in SARS in a different capacity on contract after having taken early retirement. Mr. Pillay further requested Mr. Magashula to recommend to the Minister of Finance, who was Mr. Gordhan, to approve his early retirement subject to the provision of Section 16, subsection 6D of the Public Service Act, in terms of which the Minister approves that the penalty imposed on his pension benefits as envisaged by Rule 14.3.3b of the Government Employment Pension Fund rules be paid by SARS to the Government Employment Pension Fund on his behalf. In this regard, Section 16, subsection 6D of the Public Service Act does not exist. It is clear that regard was had to Section 16, 6A and B of the said Act, which reads as follows. A. An executive authority may, at the request of an employee, allow him or her to retire from the public service before reaching the age of 60 years if sufficient reasons exist for the retirement. B. If an employee is allowed to so retire, he or she shall, notwithstanding anything to the contrary, contained in subsection 4, be deemed to have retired in terms of that subsection, and he or she shall be entitled to such pension as he or she would have been entitled to if he or she had retired from the public service in terms of that subsection. Rule 14.3.3b of the Government Employment Pension Fund rules, inter alia, reads, open quote, a member who retires on account of a reason mentioned in Rules 14.3.1d or e, and who has at least 10 years pensionable service to his or her credit, shall be paid the benefits referred to in Rule A above, provided that such benefits shall be reduced by 1/3 of 1% for each complete month between the member's actual date of retirement and his or her pensionable retirement date. Close quote. In a memorandum dated 12 August 2010, titled Early Retirement of Deputy Commissioner Ivan Pillay with Full Retirement Benefits, Mr. Magashula requested Mr. Gordhan's approval for the early retirement of Mr. Pillay with full benefits with effect from 1 September 2010, whereby SARS pays the penalty to the Government Employment Pension Fund. Mr. Magashula further requests Mr. Gordhan to retain Mr. Pillay as Deputy Commissioner of SARS on a 3-year contract with effect from 1 September 2010. This memorandum further informed Mr. Gordhan that Mr. Pillay, who was 56 years old at the time, has decided to take early retirement for personal reasons. It motivates that the Government Employment Pension Fund had approved in excess of 3,000 requests for early retirement from various government departments for staff members to retire before the age of 60 with full benefits, and that the former Minister of Finance, this is in reference to Minister Trevor Manuel, and Mr. Gordhan had himself approved at least 5 such requests over the past 2 years. It further informs Mr. Gordhan that advice was sought from the Acting Director General of the Department of Public Service and Administration, that's the DPSA, who confirmed that there is no restriction on the appointment to the public service or the same department of a person who was retired on an employee-initiated severance package. It further advises Minister Gordhan that the financial implications to SARS would be an amount of 1,141,178 rand and 11 cents, which SARS will be liable to pay to the Government Employment Pension Fund. The erstwhile Acting Director General of DPSA has since provided an affidavit to the investigating officer after having been subpoenaed in terms of Section 205 of the Criminal Procedure Act. In this regard, he was informally approached by Mr. Magashula, who sought information and clarification in relation to the employee-initiated severance package applicable to the public service. It was explained to Mr. Magashula that the employee-initiated severance package was introduced in the public service through a determination issued by the Minister of the DPSA to enable employees to exit the service voluntarily where such employees were affected by transformation or restructuring within their respective departments, and that such a severance package would include pension benefits without scaling down of pension benefits in terms of the pension benefit rules, severance pay amounting to 2 weeks' salary for every full year of service, leave pay inclusive of capped leave, compensation for medical benefits, and services bonuses, etc. The employee-initiated severance package was clearly not applicable in Mr. Pillay's case. In respect of Mr. Magashula's inquiry whether employees exiting the public service on an employee-initiated severance package as to whether such a person can be re-employed into the public service, Mr. Magashula was advised that there was no restriction of the re-employment of such employees. Mr. Magashula was further advised that in the event that the employee concerned left on a voluntary severance package, the employee concerned would only be permitted to be reappointed if the relevant department was unable to recruit suitable candidates, and that the reappointment of such former employee would only be on a fixed-term contract limited to a maximum period of 3 years. Mr. Magashula at no stage referred to Mr. Pillay nor any specific SARS individual. In this regard, Mr. Pillay's name was never mentioned to the Acting Director General of the DPSA was clearly stated that he did not provide any advice to Mr. Magashula on the specific early retirement of Mr. Pillay, nor on Mr. Pillay's retention in SARS on a contractual basis. Whilst the memorandum is not signed by the erstwhile Deputy Minister of Finance, Mr. Nhlanhla Nene, Mr. Gordhan's approval is only obtained on 18 October 2010. Mr. Nene provided an affidavit to the investigating officer after also being subpoenaed in terms of Section 205 of the Criminal Procedure Act. Mr. Nene explained that as a Deputy Minister, he did not have any power to exercise executive functions, including those in respect of the memorandum concerned. Mr. Nene was of the view that such an explanation would be speculative under the circumstances. Mr. Nene further had no recollection as to whether this specific memorandum had served before him for comment, and of course was unable to explain how he would have dealt with the memorandum had same been presented to him. As a result, Mr. Pillay's early retirement with full benefits, as approved by Mr. Gordhan, was implemented with effect from 31 December 2010. In this regard, Mr. Pillay also entered into a 5-year employment contract with SARS as the Deputy Commissioner of SARS with effect from 1 January 2011 to 31 December 2015, instead of on a 3-year contract as approved by Mr. Gordhan, and instead of in a different capacity. In addition, on 1 April 2014, a new employment contract was entered into between Mr. Pillay and Mr. Gordhan, whereby Mr. Pillay would act as a Commissioner for SARS for a period of 5 years. In this regard, Section 7 of the SARS Act provides for an acting Commissioner to be appointed for no longer than a period of 90 days only. Mr. Gordhan was offered an opportunity to provide his version to the Hawks, which version he subsequently submitted through his lawyers, and in which Mr. Gordhan stated that he approved Mr. Pillay's early retirement with full benefit on the strength of the recommendation by the then Commissioner of SARS, Mr. Oupa Magashula. Mr. Gordhan is further recorded to have approved Mr. Pillay's early retirement with full benefits, being mindful that Mr. Pillay wanted to gain access to his pension fund to finance the education of his children, and that he believed it to be entirely above board, and because he thought it appropriate to recognize the invaluable work Mr. Pillay had done in the transformation of SARS since 1995. On the recommendation of the prosecutor, and having perused the evidence and in consultation with the Director of Public Prosecution for Gauteng, Advocate Sibongile Mzanyati, the Acting Special Director of Public Prosecutions and Head of the Priority Crimes Litigation Unit, Dr. Turi Pretorius SC, has decided that Mr. Pillay, Mr. Magashula and Mr. Gordhan must be prosecuted and arraigned on inter alia the following crimes. Count 1, fraud in respect of the 1,141,178 rand and 11 cents, whereby the aforementioned persons had misrepresented to the Government Employment Pension Fund and to SARS that Mr. Pillay was entitled to full pensionable benefits in terms of the employee-initiated severance package, which was implemented for transformation initiatives, whereas in fact the aforementioned persons knew well that the employee-initiated severance package was not applicable to Mr. Pillay. Count 2, only in respect of Mr. Magashula, a contravention of the Public Finance Management Act, in that Mr. Magashula, as the accounting officer, had caused SARS to incur irregular, fruitless and wasteful and unauthorized expenditure in the amount of 1,141,178 rand and 11 cents. Count 3, only in respect of Mr. Pillay and Mr. Magashula, a charge of fraud in relation to the employment contract for duration of 5 years. Count 4, in respect of Mr. Pillay and Mr. Gordhan, in relation to the extension of the employment contract. The three accused have today been informed of the decision to prosecute them, and they have been served with J175 summonses listing the charges and in terms of which they are required to appear in the Pretoria Regional Court on 2 November 2016. As I sit before you today, I reassure you of my commitment to my oath of office to uphold